Good morning. Today we will discuss the topic of internal reconstruction. A reconstruction is a process of the reorganization of the company. We will see here meaning of the internal reconstruction. A reconstruction means the reorganization of the any firm or business or company. It takes place when the financial position of the company is not good due to the overvaluation of assets, accumulated losses, etc. It is the reorganization with the view to run the company efficiently in the future. It involves a writing off accumulated losses, fictitious assets, and overvaluation of assets out of the sacrifice of the stakeholders, which is shareholders, debenture holders, and creditors, so as to give a realistic view of the financial position of the company. Here we see needs of the internal reconstruction. Internal reconstruction is necessary due to the some conditions, means financial statement not true and fair. When the company is making the heavy losses, the financial statement do not show true and fair view of the state of affairs of the company. In that time, internal reconstruction is needed to the company. Then, secondly, assets. The asset side of the balance sheet of the company may have intangible assets, fictitious assets, accumulated losses, deferred revenue expenditure, etc. The real assets are shown at high value. Due to losses, adequate depreciation may not be provided. Stock may be valued at a higher rate. No provision may be made for the bad and doubtful debts. That time, internal reconstruction is needed to the firm. Third condition is liabilities. The company may be secured and unsecured loans which may not be repaid. It may become overdue. Interest on loan may be in arrears. Creditors may be long overdue. Preference dividend on the preference shares may be in arrears over the long period. Capital. Capital of the company is lost due to the drastic falls in the value of assets. It is not represented by the real value of the assets. Then a reconstruction. Due to the continuous losses, basic structure of the company get the damage. The pillars on which the superstructure is based become the weak and the company may be collapsed at any time. Hence, the company has to be placed on the strong foundation in order to ensure the stability in the future. Then we see the provisions under Section 61 of the Companies Act 2013. A united company having a share capital may, if so authorized by its article, alter its memorandum of association in its general meeting to increase the authorized share capital as it think fit, consolidated and divided all any of its share capital into the share or the longer amount than its existing shares. Convert all or any of the fully paid up shares into the stock and convert that the stock into fully paid up shares of any denomination. Subdivide its shares into the share of smaller amount than the fixed by the memorandum of association. Cancel shares which have not been taken or agreed to be taken by any person. Then we see here the capital reconstruction, capital reduction. A reduction of the share capital under Section 66 of the Company Act 2013, effective from the 15th December 2016. A company limited by the share capital or the limited by the guarantee and having the share capital may by the a special resolution reduce share capital may existing or reduce the liability on the share in respect of the share capital not paid up or either with or without extinguishing or reducing the liability on any of its shares, cancel any paid up shares capital which is the lost, or pay off the any paid up share capital which is excess of the requirement of the company. The company may take an application to the National Company Law Tribunal for the confirmation of the reduction of share capital. Any application to confirm the reduce of the share capital shall be accompanied with the list of creditors, certificate of the auditor clarifying the list of creditors, the certificate from the auditors and the declaration by the director by company is not arrear in the repayment of the deposits or interest thereon. Certificate by the auditor that the accounting treatment for the reduction of capital in its conformity with the accounting standards specified in the section 133. The National Company Law Tribunal shall within 15 days give the notice or direct that notice to the central government register of the companies SEBI creditors seeking their represented and the objection if any. The tribunal shall give directions for the notice to publish the English newspaper and the vernacular language newspaper having wide the circulation in the state in which the registered office or the company is situated. The notice shall state that the amount of the proposed reduction of the share capital, the objective, if any, shall be filled in the tribunal within 3 months from the date of the publication notice. The central government registrar, etc., may be representation to the tribunal under section 66 within the 3 months of notice. The tribunal may be give such directions regarding handling or any inquiry or the adjudication of the claiming for hiring the shareholders, hiring the objections by the shareholders. At the hearing of the application, the tribunal may be give directions with the reference to security debt or claims of the creditors who do not consent to the proposed reduction. The tribunal may be an order confirming the reduction and approve the minutes. The company shall deliver a occupied certified copy of the order to the registrar within the 30 days showing the amount of the share capital, the number of the shares into which is to be divided, the amount of the each shares, the amount of the deemed to be paid up. The registrar will register the order and memorandum of association standard amendment. If a company falls the company with the provisions, it shall be punishable within with the fine which may be extend from the 5 lakh to 25 lakh. Then we see the procedure of the reduction of capital. First is ensure that articles of association authorize the reduction of capital. If there is authorization alter of the articles of association as per section 14 of the Companies Act 2013, then convey the board meeting, approve the scheme of capital reduction, fix date, time and value of the holding general meeting for the passing special resolution. The fixed date, time, and venue of the holding general meeting for work for the passing. Issue notice of the general meeting to all members, directors, and the auditors of the company. Then we hold the general meeting and pass the special resolution. Then file e-form MGT14 along with a certified copy of the special resolution, copy of the explanatory statement, copy of the altered memorandum of association and articles of association within the registrar within 30 days. The tribunal shall give a notice of application to be the central government register, and the creditors of the should not creditors of the company and take into the consideration and representation received within the 3 months. The tribunal, if no representation is received, confirm the account is reviewed. The tribunal, if no the tribunal, if no representation is the received, confirm the reduction of capital. The order of the tribunal shall be published in the company in such manner as the tribunal may be directed. Then we see the difference between internal and external reconstruction. First difference is found in the meaning. Internal reconstruction is a internal reorganization of the company, but external reconstruction is the process of the liquidation and takeover. Then difference in liquidation. The company is not liquidated in internal reconstruction, but it is liquidated in the external reconstruction. Then difference is found in the takeover. It does not involve take of the business in internal reconstruction, and the company is liquidated and it is involved takeover of the business in the external reconstruction. Then new company. There is no new company formed in the internal reconstruction, and a new company is formed to take over the business in external reconstruction. Then modes. Internal reconstruction may take place through the fresh issue consolidation, subdivision of the shares, cancellation of the unissued shares, etc. Then a new company is formed to take over the business. It may place through the liquidation and the takeover. Then we see the difference between internal and external reconstruction in the modes. It may take the place through the fresh issue consolidation, subdivision of the shares, cancellation of the shares, and external reconstruction may take the place through the liquidation and takeover. Then we see the difference between the legal formalities. There are concern with the alteration of the share capital in internal reconstruction, and a new company is formed to take over the business, and it may take place through the liquidation and overs. Then we see the difference in legal formalities. There are concern with the alteration of the share capital, and external reconstruction are concerned with the liquidation after the debtor. Then objective. The objective is to be write off the losses out of the sacrifice by the external claimants and the place of the company on the strong financial base. The objective is to be taken and over the increasement त्या ठिकाणी करणं महत्त्वाचं असतं. The objective is to take over and increase the comparative strength. Then we see the difference in the section. Internal reconstruction is done as per section 66 of the Companies Act 2013, and external reconstruction is done as per the section 309